I call the meeting to order, and if you'd please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Debbie, please call the roll.
Mr. Haggard?
Here.
Mr. Rucker?
Yes.
Dr. Colgan?
Here.
Mrs. Stanford?
Yes.
Mrs. Hodges?
Here.
Mr. Sneeden?
Here.
Mrs. Prusman?
Yes.
Thank you. For the approval of the agenda, can I entertain a motion to approve that?
Second.
First and a second. Any questions, comments? All right, Debbie, would you please call the roll?
Mr. Rucker?
Yes.
Dr. Colgan?
Yes.
Mrs. Stanford?
Yes.
Mrs. Hodges?
Yes.
Mr. Sneeden?
Yes.
Mrs. Prusman?
Yes.
Mr. Haggard?
Yes. Okay, now I would like to call for nominations for secretary to the board, please.
I'd like to make a motion to nominate Debbie Consolver. Second.
We have a first and a second. Do we have a motion to cease nominations?
Second.
Who made that motion, Mr. Haggard?
Martin.
Martin, okay.
And Dan? With the motions to cease, Debbie Consolver is declared secretary of the Board of Education for the next 2 years.
Mr. Chairman,
I'm sorry.
you need to vote on that motion to cease nominations.
I'm sorry. It's not on my list.
Sorry. Dr. Colgan?
Yes.
Mrs. Stanford?
Yes.
Mrs. Hodges?
Yes.
Mr. Sneeden?
Yes.
Mrs. Prusman?
Yes.
Mr. Haggard?
Yes.
Mr. Rucker?
Yes.
Congratulations, Debbie.
Congratulations.
I know it's a shock.
Okay, now I'd like to ask for nominations for an interim treasurer.
Okay, I'll nominate Kim. Is it Mulvaney?
Mulvaney.
I'll second.
I have a first and a second. Do I have a motion to cease nominations?
So moved.
Second.
Debbie, would you please call the roll?
Mrs. Stanford?
Yes.
Mrs. Hodges?
Yes.
Mr. Sneeden?
Yes.
Mrs. Prusman?
Yes.
Mr. Haggard?
Yes.
Mr. Rucker?
Yes.
Dr. Colgan?
Yes.
Thank you. Kim Mulvaney was declared elected interim treasurer for the board for the next
We don't know when.
Little bit.
until further notice. She did.
What's that last name again?
Mulvaney. Dr. Czerwonka.
Number 3, letter of engagement for Mickes, Goldman, O'Toole. Debbie Matthews. This is the letter of engagement with Mr. Mickes in regards to representing the school district. I want to make clear, because I believe there's been we've been not told correctly. Mr. Mickes is not my personal attorney. I've never retained the services of Mr. Mickes as a personal attorney. He represents school districts. He represents hundreds of school districts across the state of Missouri. And when he represents a school district, he also serves as the board's attorney. So this is in regard to, when you see here, he classifies this, the scope of work as the project. And I was asked, what has Mr. Mickes done to date for the district? And I asked him for a summation of that thus far. And let's get this report will show. And this is from Mr. Mickes, and you'll see that is on the front page. I'll be glad to kind of give you the highlights, just so you know where we're at and what we're doing. The first one is A. This is called Jurisdiction Authorizing a Federal Investigation. This is in regards to the FBI investigation. At various times during the present investigation into the St. Joseph Public Schools, this is Mr. Mickes' words, I have inquired about the basis of the existing federal investigation. Agent Lipanovich has consistently used the analogy that if one drop of federal funds was placed in the district's operating funds, there is federal authorization to review all district operations. However, federal education dollars are not commingled with state and local revenues. Rather, these federal funds are segregated into individual funds for each source of federal funds. Each discrete federal account is audited annually and reviewed by the Missouri Department of Elementary and Secondary Education. For example, the following discrete federal accounts have been audited by the district's outside auditor, Westbrook & Company. In the 2009 audit, the following federal accounts were audited: Child Nutrition Cluster, Title I, Title IIA. Specifically, the auditor stated there were no significant deficiencies disclosed during the audit of major federal award programs. The auditor's report for the major federal award programs for the district expressed an unqualified opinion. There were no audit findings relative to the major federal award programs for the district reported in this schedule. In the 2010 audit, the following federal accounts were audited: State Stabilization Fund Cluster, Title I Cluster, IDA Cluster, Homeless Education Cluster. Specifically, the auditor stated there were no significant deficiencies disclosed during the audit for the major federal award program. Turning to page number 5 at the top, the auditor's report for the major federal award programs for the district expressed an unqualified opinion. There were no audit findings relative to the major federal award programs for the district reported in this schedule. In 2011 audit, the following federal accounts were audited: ARRA, State Fiscal Stabilization Fund, Federal Education Jobs Bill, IDA Cluster, Title IIA. Specifically, the auditor stated there were no significant deficiencies disclosed during the audit of major federal award programs. The auditor's report for the major federal award programs for the district expresses an unqualified opinion. There were no audit findings relative to the major federal award programs for the district reported in this schedule. 2012 audit, the following federal accounts were audited: ARRA, State Fiscal Stabilization Fund, Child Nutrition Center. Again, the auditor states there are no significant deficiencies disclosed during the audit of major federal award programs. The auditor's report for the major federal award programs for the district expresses an unqualified opinion. There are no audit findings relative to the major federal award programs for the district reported in this schedule. 2013 audit. Opinion on each major federal program. In my opinion, the district complied with all material respects within the types of compliance requirements referred to above. Auditor's responsibility that could have a direct or material effect on its major federal programs for the year ending 2013. Again, 2013, they made the following discrete federal program in regard to federal programs: ARRA, State Fiscal Stabilization Fund, Federal Education Jobs Bill, IDA Cluster, Type 2A. Specifically, the auditor stated there were no significant deficiencies disclosed during the audit of major federal award programs. The auditor's report for the major federal award programs for the district expresses an unqualified opinion, and there were no audit findings relative to the major federal award programs for the district reported in this schedule. Moreover, the Department of Elementary and Secondary Education reviews the receipts and expenditures of each federal program administered by the district. DESE has not cited the district for any in its district administrated federal programs. Irregularities. Thank you. For at least the last 5 years, the district's finances have been audited by likely the best school auditing firm in Missouri and have received unqualified audits. These audits are reviewed with the St. Joseph Board of Education on an annual basis, and he has attached the last 5 audits for the district by Westbrook & Company. In summary, the audits attached here too clearly establish that all federal funds are segregated from the district's operating funds, are audited separately, comply with all federal and state regulations, and have been approved by the state of Missouri. To date, the alleged commingling of federal and state funds has been the only basis for federal investigation into the district's financial practices. The records attached here too clearly document neither St. Joseph Public Schools nor any other Missouri district commingles federal and state funds. If there's some other authority for federal involvement, please notify me, meaning Mr. Mickes. Otherwise, it clearly appears that this is a matter for local law enforcement and the state auditor's office. The documents that follow are those 5 years of audits that he's passed. Moving on to tab B. This is in regard to stipends of paid to $5,000 paid to most district administrators. In summation, shortly upon assuming his duties as superintendent of schools on July 1st, 2013, Dr. Fred Czerwonka saw a need to increase administrator involvement in community organizations and increase attendance at district evening activities. As of July 1st, 2013, there is no requirement that administrators perform such extra duties. Therefore, the superintendent, in consultation with board president Dan Colgan, authorized the stipends for all administrators except Dr. Czerwonka, his spouse, and high school principal Sumi. However, in each case, the stipend was a total of $5,000. A few employees received adjustments as they were not on the proper salary schedule. The transfer reflected an increase in the length of contract and/or additional duties that were assigned. Issues have arisen concerning the legality of these stipends. A number of statutory provisions are relevant. For instance, Article 3, Section 39 limits the power of the General Assembly to grant extra compensation to a public officer after services have been rendered or a contract has been entered into and performed in which or in part. There's a copy of that enclosed in here. This provision has been expanded to include a similar prohibition against public school districts, Attorney General Opinion 6-85. However, succeeding Attorney General opinions, for example, the opinion 171-71 and 211-70 have limited the prohibition to situations when a public employee's compensation was increased without the addition of responsibilities and duties which were not previously contracted. Thus, the consistent accepted understanding of the law is that a contracted public employee may have their contractual salary increased only if these are additional duties and responsibilities for which the employee had not previously contracted. In the present case, the stipends were given for the performance of additional duties and responsibilities. The district has records indicating the fulfillment of these duties and responsibilities for administrators who receive the stipends. Board Policy CB. The school superintendent also authorizes the superintendent to give directives which shall be valid until disapproved by the board for the management of the district to employees and students on points not covered by adopted policies, rules, and procedures. At the time of Dr. Czerwonka's stipend directive, there were no procedures to mandate administrator involvement in community organizations or participation in evening activities. Consistent with Policy CB, the Board of Education considered whether to approve or disapprove the $5,000 stipends at its meeting February 10th. At the meeting, the board was given 3 options: affirm the stipends, disapprove and terminate the stipends, terminate the stipends, require the stipends to be paid to date and returned to the district. As noted in the closed minutes, Mr. Rucker moved to affirm the stipends. Ms. Stanford seconded the motion. The motion was approved unanimously. Contrary to some speculation, the stipends were not unlawful bonuses, but rather additional compensation for the assumption of new duties and responsibilities. The enclosed Missouri Attorney General's opinion clearly support the difference between these opposing scenarios. Moreover, the Board of Education, pursuant to its authorization, considers its options and unanimously approved the stipend.
Okay, I'd like to stop right there. Excuse me, Dr. Czerwonka.
Constitution, and I'm sorry.
Just for a moment there, because I see the minutes, I see what he's written here, but he doesn't have the discussion that went with that. And there was a discussion that went with those 3 options. That this makes it sound like the board said, well, yes, let's just go ahead and do the stipends. But my recollection is that there was discussion with council with the discussion of what to do. Do we take those stipends away from the people that are already getting them? Should we be in compliance and retroactively approve those stipends so that we are in compliance? But none of that seems to be in this particular document. Just for a record out there, I want you to know that.
It's my understanding, Ms. Stanford, that in closed session you have to have the motion. Who made the motion? Who seconded the vote?
That's right. So the discussion's not in there, but the discussion is relevant to why we did the vote. If somebody wants to ask me why I made my vote, I'll be glad to say.
Is that correct?
Ms. Stanford. I'm not disagreeing with you, but I'm not going to discuss in open or in public session any attorney-client discussion.
Absolutely,
Right.
but I
understand
can, my individual vote, say,
Yes.
this is the discussion, and this is why I voted the way that I voted. Thank you.
It's my understanding
Yeah.
that we're not to discuss closed session items.
I concur, but that's, I understand where you're going. She's making a point about conclusions.
What you have behind that is the documentation of the board minutes along with board policy, Attorney General, the citing of the Attorney General, Missouri Attorney General, and Constitution. C, this was a question that has been raised about board member Dan Colgan paid health insurance. An issue has been raised concerning the district's payment of health insurance premiums for Dr. Colgan. As with many of the allegations and rumors surrounding this investigation, the accusers have failed to review the facts before launching personal attacks. In the superintendent's contract of July 1st, 2002, the Board of Education offered to pay the superintendent's health insurance for life if he agreed to forego other employment opportunities and remain with the district for 3 years. Such insurance was to be secondary once Dr. Colgan became eligible for Medicare. He is now so eligible, and the district's cost of insurance has been reduced. There's a contract that's enclosed that outlines this. Dr. Colgan's July 1st, 2002 contract was submitted to the Board of Education at its July 11th, 2001 meeting. During the board's discussion, as set forth in the board minutes, the provision of individual health insurance for life was specifically discussed. As you will note, Dr. Colgan was not present during this discussion. Rather, Dr. Colgan was invited to return to the meeting after this contract was approved unanimously. You can see the minutes from June 11, 2001. Promotion of Dr. Colgan's son to the position of Technology Director. Board minutes, copies enclosed, revealed that Dr. Colgan did not participate in the discussion and refrained from voting on employment and salary of his son. For example, in the board's March 10, 2014 meeting, the salary schedule for Mark Colgan was passed 5-0. with Dr. Colgan abstaining. In spite of the fact that Dr. Colgan abstained from voting on matters involving his son, allegations have continued that Dr. Colgan's actions were somehow unlawful, although no references have been made to any law alleged to have been violated. To be clear, statutes and board policies support the appropriateness of actions taken by Dr. Colgan. Article 7, Section 6 prohibits any public officer from naming any relative to public office. The case interpreting Article 7 have differentiated situations where an official, sheriff, county judge appoints a relative from situations where a relative of one board member is hired by the board with the vote of affected board member. For example, he gives an example of state relative Attorney General V. Shull, the Missouri Supreme Court invalidated a hiring where the relative board member is voted to employ their relative. Here, there is no suggestion or evidence that Dr. Colgan voted for his son. Section 168.126.1 prohibits the employment of any persons related to a board member who's related within the 4th degree of
consanguinity.
Yeah, thank you. Where the vote of the board member is necessary for the selection of the person, emphasis added. Again, the vote was 5-0 with Dr. Colgan abstaining. Finally, board policy GDC supports staff recruiting and hiring provides requirements consistent with section 162.261 RSMO for employment of spouses of board members. Even a cursive review of board minutes and the law revealed the attacks on Dr. Colgan and his son to be spurious. What you see after that is executive session minutes, his contract, and reflected that, Missouri Constitution, Article 7, Missouri revised statutes, and board policy on staff recruiting and board minutes. Tab D is what was referred to earlier, contract for Dr. Conrad Sumi. Prior to the beginning of the 2013-14 school year and prior to Dr. Czerwonka assuming the duties of superintendent, there was a concern that Dr. Sumi would accept a contract from another district, thus joining the departure of the district's other two principals. A decision was made, assumedly with the knowledge of the prior superintendent, to increase Dr. Sumi's contract by $8,000, which resulted in retention of a quality principal. The new contract was issued, reflecting the salary increase. This contract is dated June 11, 2013, prior to any performance by Dr. Sumi on the contract for 2013-14 school year. When Dr. Czerwonka increased the duties and responsibilities of administrators for 13-14 in exchange for a stipend, later unanimously approved by the board, Dr. Sumi was not given the stipend. She was required to perform the additional duties, but in Dr. Czerwonka's consideration had already received an increase. And there's a copy of the contract. And the last tab is E, public or policy DB, annual budget, provides as follows. This is in regards to the flipping group. The total amount that may be expended during the fiscal year for the operation of the school district are set forth in the budget. The total budget expenditure for each program is the maximum amount that may be expended for that classification of expenditures during the school year unless earmarked revenue for that program exceeds the budgeted amount or budget transfer is recommended by the superintendent. Prior to Dr. Czerwonka's arrival, the board had approved a budget that, among other things, provided a specific amount of professional development. On July 1st, 2013, the morale of the staff was in crisis because, among other things, the departure of a large number of key employees. Dr. Czerwonka had worked with the flipping group, has had a large number of school districts in team building, enhancing morale and education focus on the district students, or education of district students. The flipping group successfully presented at the convocation to start the year off with staff enthusiasm. To date, all board members, as well as 123, and that was prior to our board change, but all 123 staff members have received training through the flipping group. 320 social contracts have been created in district buildings and classrooms, and positive results are readily apparent and well within budget. Interestingly, though, the district's attendance rate has increased by 1% or more, which generates approximately an additional $600,000 in state revenue. Can it be directly attributed to the flipping activities? No. But it has an impact on student attendance. More importantly, district students are at school learning more this year than in the past. This is a positive outcome to which all should welcome. Finally, the board, and to some extent the integrity of board members, has been questioned. One can read in the media and get the impression that rogue individuals run the district, but the reality is that the district operates under a budget adopted in a public meeting. It retains an outside auditing firm to audit its financial operations. It is a district that has received unqualified audits for at least the last 5 years. In a district that has a legal counsel at all its meetings to advise the board and to review finalized board minutes. The facts seem to have been lost in a rush to judgment. And then what you'll see there is a copy of the policy of training budget. So, when asked the scope of work, asked what has he done to this point, asked where we're at, this is everything, this is his report to this point.
Who all will be provided a copy of this?
U.S. Attorney, FBI's office, and of course the board, and everything in here is public document, so I'm assuming there will be that.
Okay, so can we go back to the engagement? Well, does anyone have any questions on this? I know we just got it, so
Right, yeah, we got it today, we've been busy putting it together.
take some time to look through it.
I'd like, how much has his work cost the district so far?
I'm not sure, I don't know how many hours he's spent with the district so far preparing this.
Would you please find that information out, and if you could just email that to the board, that would be appreciated. Sure. Thank you.
Is he working on other stuff?
Yes.
So this isn't like a summary, and he says, okay, there you go. There's more that he's doing.
This is a summary up to this point. He feels that there is no issue at all with the FBI. This is, like I said, there's a copy of this going to the agents and to the U.S. Attorney.
Dr. Czerwonka, I want to go back to her question. She said, is he working on other stuff? Now, if my recollection is correct, we got to Mr. Mickes in the first place when we had an issue and our present counsel stepped aside because of conflict of interest. Isn't that correct?
Correct, yes.
With our insurance liability firm?
Yes.
Is that right?
Yeah, he worked, like I said, he works for over 250 school districts, 300 school districts across the state of Missouri. So.
Okay.
And whenever a district has an insurance claim, the insurance carrier assigns the attorney.
Okay, so
And
we
that's
have,
paid by the insurance company.
I'm sorry?
And that's paid by the insurance company
Yes, sir.
at that point in time.
And so that is how we initially have Mr. Mickes involved with the school district, is that correct?
Correct.
And so he's working on that for the insurance company also, is that right?
That's a
separate issue, right?
Yep.
Separate
Okay.
issue.
This engagement here came from the FBI investigation only, is that
Correct.
correct?
And so I clarify, he represents the board, not me, this district and the board.
Just wanted to make sure that was clear.
But we haven't voted for him to represent the board,
Exactly.
That's what this engagement letter is for.
but he's done the work. Let's see.
Well,
What insurance company is doing the claims? I know it used to be MoPerm, so who is it?
we used to
Doug
do
would
Catlin.
answer that.
Catlin?
How do you spell that, Mr. Flowers?
Catlin.
And they are based where? Jeff City?
I think they have multiple offices around the country. I think they have one stationed in St. Louis, I believe.
Thank you.
And it could also be, MoPerm could also be involved. We switched carriers July 1, 2014. So anything prior to January 1 of 2014 would be MoPerm. I believe they're stationed out of Jeff City. Anything after January 1st would fall in the new company.
After July 1st?
After January 1st, sorry.
January 1st. So
January 1st, 2014, we changed carriers.
Oh, that was, I understand, not for the school year, got it.
And if, Mr. Rucker, if you recall, the FBI were here on April 10th. I believe the day they showed up. April 11th, we had an event. I went to board policy. The event was, we were at Missouri Western, Mr. Braves, yourself, Mr. Haggard, myself. And I went to board policy. It says, when the administration concludes that unusual types or amounts of professional legal service may be required. Here to tell you, the FBI, I've never seen the FBI at a school district in my life. So it's very unusual. The board directs the administration to so advise them. The board president, board vice president, to the legal counsel, and to expeditiously seek either initial or continuing authorization for such service. I sought initial, and now I'm asking for continuing.
It does say that, but it doesn't say that you go to the board president and vice president there. I mean, our board policies are, it's the board, the board, the board. And so if anyone would like to see this policy, feel free to pass it around.
Will do, thank you.
Thank you.
I will crossfire. They gotta go through the chair, one at a time. Everybody gets to say what they want.
Well, is there a motion? I mean, before we do any further discussion,
you do not have a motion on the floor.
well, before there's any further motion, is there a motion? Or before there's any other discussion, is there a motion?
I make a motion that we accept the letter of engagement as a board.
Is there a second?
I'll second that.
Okay, we have a first
now
and a
we have-
second.
we have discussion now?
Yes, questions.
Well, if he's already done this work, don't we have to at least pay him for what he's done? Even if we didn't want to continue? So we kind of have to okay at least this much? Is that correct?
He has performed the work, yes.
Right. And then we could decide if we wanted to continue or to not as well.
Yes, ma'am.
Just making sure I understand. I'm a little new.
Dennis?
You know, this is almost like a history lesson. You know, you learn from history, you don't relive it. I think where we get ourselves in trouble, especially with the public, is that things like this are done, and it's reasonable why, but it's always better if we don't do this anymore. Whatever comes down the pipe, get the whole board, and let them vote. I would have to agree with Chris here a little bit. This is just like the bonuses. It was legal for Dr. Fred to do what he did, but it would have been better and easier, and we would avoid a lot of trouble if the whole board was in on it from the very beginning, from Dr. Sumi on, and like the lawyer here again. You know, sometimes maybe you don't have time to do it, but with all this electronic stuff, which I'm the worst, by the way, I'm last to get my messages and whatnot, but I think we've learned a hard lesson here. And the bad part of it is the kids may suffer, the teachers, the levy, you know, everybody doesn't trust us now. But I think from this point on, whatever comes down the road, my recommendation is, unless it's life or death, get the whole board involved, and then we'll learn from history. We necessarily won't relive history.
Sure, but Mr. Sneed, if I could recall to you, this happened on Thursday. They showed up. Friday, they decided to interview board members. They started setting that up for, I thought, Saturday or Monday. I don't recall the times. I contacted they interviewed board members on Friday. I contacted, after we talked, on Friday evening, I contacted every board member who had not been interviewed, and as well as Mr. Mickes.
You called me.
Because the policy says to expeditiously to do that. And when you have an emergency situation or unusual type of situation, I wish we could have time to do that. But in this case, we didn't. If we do, we will definitely do that.
I hear you. And I'm not questioning your integrity at all.
I understand. I'm just saying I wanted an explanation of why we had to move quickly, because he represents the board.
I just think we're at a point now, though, from now on, whatever comes down the pike, let's make sure that each and every one of us are aware of what's going on. That's all. I'm not going to talk too much.
Ms. Stanford.
Well, and I think that the use of an electronic forum has been used before when we had a crisis down at Lake Contrary. You sent us a text. I mean, when a student's been missing, we have the Amber Alert, you've sent us a text. And I think that would have been an appropriate time to do that too. Thank you.
Mr. Rucker.
Mr. Sneeden, I know hindsight's what's way to go, but
sure.
I want to say also I agree with what you're saying, and I just wanted to let you know that my thought process was to help protect the rest of the board. Myself, it didn't help me at all. I had already talked to the FBI agent. I was under the assumption that we needed to have protection for the board. And so the rest of the board was what my concern was, to make sure that they were protected. Whatever that might be, I don't know.
Well, I appreciate that.
And that's what that was, that's why I gave my okay. It didn't help me at all. I had already talked to the FBI agent. So, just wanted to let you know.
When they called me, I thought it was a joke. The joke was on me.
I got a question on the rates. It says the rates are $225 for Mr. Mickes, $170 for Mr. Musil, and then $130 for paralegal. Are those appropriate rates?
I asked Briggs, and he said they were. These aren't on. I tried.
Oh, okay. Mr. Haggard, members of the board, I haven't seen the engagement letter, but the rates that are reflected in it were the rates that were reflected in the article in the newspaper. I believe that the rates are reasonable for the nature of the work being done, ranging from, I think the top rate is $2.25 or $2.20, and so the attorney rates are ranging from $175 to $225. I think the rates are reasonable for engagement or work of this nature. I don't think they're out of line.
Brett, when I was executive director of USA Weightlifting a few years ago, we had many problems with doping issues, Olympic sport, and it was $299 an hour right off the bat. When I called our attorney, which represented many sports, we all kind of worked together. It's $299 a minute, basically, as soon as you call them. So when I saw these fees here, now I'm going to tell you, I'm probably the poorest person at this table. I'm just a lonely recreation worker now. I came down back to St. Joe, but I can tell you, this is pretty cheap. I mean, compared to what I've seen, I would consider it a bargain.
I would just like to basically go on the record just to saying that I understand all of the work that they've done. I feel like they should be paid for the work that they've been done. But I think moving forward, I think we as a board really need to look at who we want to represent us moving forward.
Any other discussion?
I have a question. Ms. Brewsman, do you have a problem with Mr. Mickes representing us?
I feel like there are conflicts of interest.
And
And
what
I
might they,
don't-
could I ask what they might be?
Well, I feel that it's, when we had, well, Fred and you guys had decided that you would contact someone, and it wasn't approved by the rest of the board. And then now we find out that he is representing the insurance company. And I just feel like something's just a little amiss there.
Okay, he represents the district by the insurance company. The insurance company picks the council, and they pick the best council in the state. So they pick the council. He represents the district in that insurance.
I understand that, but I'm just saying that in my mind, it just doesn't set well. It just seems like, and I want to be honest with you, I want to get to the bottom of it. I mean, this has been going on and dragging on, and people are on administrative leave. There's rumors circulating all throughout this community. The board is not looking good, the district isn't looking good. I want to get to the truth. I want to find out truly what has happened. I want to do it before contracts end, and I want it to be able to be out there so that everyone knows that we have all done everything that we could to make sure that the truth has come out and that appropriate actions have been taken.
And we're working as fast as we can to gather all that.
Mr. Chair.
Sir.
Okay, I'm going to ask Fred here a question. Would you consider him, this Mickes guy, is he the best in the
Yes.
state as
Yes.
far as school law?
Yes, absolutely. He has 15 attorneys in his firm, and they represent hundreds of school districts across the state of Missouri.
Okay.
Help me, Mr. Chairman, with this. Obviously, from what I'm hearing, we're talking about the work that this attorney has done, that we pay him for that work. The second point then is, again, we're talking about moving quickly and trying to get to the bottom of all of this and putting it behind us. And now we're talking about, we have an attorney that obviously knows school law, has practiced school law for many, many, many years, is an attorney that the insurance companies select because of his knowledge of school law, and we're now suggesting that we may be suggesting that we know that we sever ties with this person and start looking for another attorney, which is going to take us time, because are we going, obviously we'll go through a similar process trying just to come up with another attorney, and I'm just questioning in terms of time why we wouldn't continue with the person that has the knowledge that he already has, so that we can continue to move forward. And my only thought is that to expedite things, we continue to move forward.
Mr. Chair.
Yes.
And I realize we just got this report, and this kind of report is going to take lots of time for both all of us to go over. But in listening to Dr. Czerwonka read the report and just processing at the moment, it appears to me that Mr. Mickes has already decided that the investigations from both the FBI and the state auditor are necessary, and that there was no violation of board policies in giving the stipends and the promotions, which really then say our board policies are worthless. So I'm going to have to, maybe in a different way than Lori is saying here, Ms. Brewsman's saying, but I have issue with an attorney who hasn't talked to me, and I don't know that maybe he's talked to the rest of you, but has already made up his mind and has written a report, and that is his judgment, and we're all bowing to it. So I just wanted to make that my own point there. Thank you.
Any other discussion, questions, comments? Hearing none, Debbie, would you call the roll, please?
Mrs. Hodges?
I'm going to say yes because I think we need to pay the man.
Mr. Sneeden?
Can you read that what the motion is there I'm voting on? I want to make sure I'm not voting on it right there.
Are there two motions? Are we paying him for past work, or are we engaging him for future work?
There's one motion.
One motion.
The
as I understand it,
engagement
to
can be
approve the
ended if we
engage-
should
the
care to.
engagement letter.
That's it. Yeah, Mr. Rucker moved to approve the letter of engagement from Mickes, Goldman, O'Toole. Dr. Coggin seconded the motion.
All right, my vote's yes.
Mrs. Prusman?
No.
Mr. Haggard?
Yes.
Mr. Rucker?
Yes.
Dr. Coggin?
Yes.
Mrs. Danford?
No.
Okay, motion passes. New school construction update.
Rick, new school construction update?
You have
It's the same thing with the email from last week.
okay, and if you want to see a hard copy of this, again, I may have to borrow some of my reading glasses.
Here we go.
Thank you.
You're 275, so they ought to get you that.
One or two, but they're so smeary, you're not going to be able to see a thing.
Rick, I think there was some question on, are we on time? Are we on budget?
Well,
You've got it right there. It's right
we'll talk
there.
about the budget part first. And I know that some questions have been brought to you about the school district's over budget and that they're not going to open. I believe that what would trigger that, and I think it's a natural response, is we have a duty to have contingency plans. Okay, and so part of the contingency plan, in case we have more issues that would keep us from opening, was to try and find some non-essential areas in the buildings that we could defer and say, we know that the kids are coming on the first day of school, but the library center doesn't have to be completely finished the first day. So we identified some strategic areas that we can use the building, deliver education, and therefore be able to get the kids in. Once we started talking to general contractors, et cetera, then how you want to interpret that information could be, well, they're not going to make it. And at this point, we can't state that we're not going to make it. We still believe that we will. As this says, we have had one of the worst construction winters in our history. We haven't built anything in such a long time. We really picked a bad winter to do it, but we're doing it. I think the best thing that's happened to us is that we have local general contractors who have their reputation online. They want to make these schools open, and they also have liquidated damages, that if they are not open on time, they have a cost associated with that as well. There are some issues, as you'll see in this document, with the availability of subcontractors in some areas. And we had these conversations with the local labor groups prior about whether it would be necessary to stagger the starts of the construction and accept the fact that one would not open at the start of the school year, which was very problematic in how you could open one later. It just didn't make, they assured us that there was enough labor in this town to build them both simultaneously. There's not in several trades. And that has caused significant issues for us, the roofing primarily, okay? And they're running from one to another. Despite all those things, if you were to ask the general contractor today if they believe that they will be on time, they're going to tell you yes. We still don't know how much rain we're going to get, and on and on and on. Can tell you that we will be taking what is called the final plat document to the City Council, and I just got that confirmed this afternoon. I believe it's the last week of May, and then the first week of June is the last engagement with City Hall, and that is where they've looked at the infrastructure pieces and they say, you've done everything we asked, which they've already signed off. This is a formality to go through that process. Then after that, we have no issues or risks in receiving an occupational permit to take control of the building. Even if the LRC isn't finished or the part of the parking lot isn't done, none of those things will matter. We have no risk whatsoever in not getting an occupancy license. So we have set up a whole series of contingency plans, because we could go into 3 weeks of rain and there's going to be some problems. They have lost, between 40 and 60 days between them, the general contractors have, because of cold and snow. And despite that, they would tell you today that they're going to open them. As far as the costs, we anticipate that we will have air-conditioned all the buildings as we told taxpayers that we would. We built 2 schools as we told taxpayers that we would, and we negotiated and built the infrastructure that was required by the city to obtain those occupational licenses. I believe that we will have $5.5 million left when this is over, somewhere in that range, and that gives this board and administration a wonderful opportunity to go back, because we have an awful lot of physical plant needs, okay? And what do we do with that money? So I think you're in a darn good position here. And again, the biggest reason that I believe we're going to get them done on time, and we are this far under budget, is the engagement of moms and dads and aunts and uncles. That's who's building the schools here, and they want it to open, and they want to do it well and for a fair price, and they have.
Well, Rick, you mentioned here, I heard the new schools are over budget and won't open on time. I've not heard that. Where did that rumor come from?
Well, I don't know, but I would have to assume that once we started talking to the general contractors about a contingency plan,
have other board members heard that we were over budget?
I have heard that, and I've also heard that our change orders are extravagant.
Okay. The national average for change orders, the national average for change orders for the Midwest is 5.6% of the construction cost. We are at 0.6% change orders. We haven't hit 1%.
And this is why, I mean, I was the one that asked for it to be on the agenda, because I wanted to hear from Mr. Hartigan, person to person, and with everyone here.
This is how we take care of those concerns.
No, I think this is perfect, and it's a perfect place to have the dialogue.
In the public, and so that, because when the rumor mill starts and all the schools aren't going to open, now where my kids are going to go, where my kids are going to go if they can't go to the school. Well,
if we don't know that people are concerned, we can't address the issue.
Thank you.
No, exactly, and that's why, again, I'm hoping that any rumors regarding these kinds of things could be addressed at our board meetings on a regular basis.
I think this was addressed at least to you all immediately upon receipt of that, so that this group knew, and if you were then stopped and you got the same information, you've got...
Well, and
I can see the schools are going to be on time, and we're...
And maybe another suggestion, much like Chris's suggestion with informing all of the board, Dr. Czerwonka, if you could somehow, I want to hear these rumors. I want to know myself, so that again, I'm providing the appropriate information to people that are asking. So when rumors come up, could you email or call us, let us know, so
Yeah, I just copied
there's
everybody the email that Stanford sent.
Right. Well, and I think, I think for something like this, I mean, there's one thing when we're using an electronic form of communication for Amber Alert or for for a contract for an attorney, but it's another thing when it affects the community, and I think those kind of things need to be in a public forum. I mean, I think...
Yeah, and discuss them then in the public forum afterwards. Bring them, but it may be that we walk out of this room and we're going to hear a rumor that the roof on one side of the building collapsed because of all the rain we've got. Who knows what? And being able to know that that's not true, or there is a problem, and so on, and then address it at not only let us know, but then address it at the next board meeting, because our next board meeting is not going to be for another week and a half or so.
And I'll go ahead.
I don't mean to put a stop to all this, but we're always going to be trying to answer these websites or whatever that people are just blanket make statements, not being held accountable, not putting their name on anything. Look, right now, what I'd like to see us focus on is the transfer policies. The kids that want to stay at one school, can we get them into school they want to go to? I want to get back to school board business more than anything. I saw Brian Schindorf here. Is he still here? Brian, I know I asked you, I hope I'm not going crazy here, but remember I asked you to start getting a plan together. I hope at the next personnel meeting, I don't know if that's where you want to bring it to the committee before the board, but I'd like to get that going because we're almost at the end of school. We want to be able to tell the parents exactly what the plan is, and if there's a seat open in a school and they want it, let's give it to them. You know, they can get the rides there and all that. So I don't mean to change the subjects here, but I'm worried about that. I'm worried about that. That's one thing I'm worried about.
Actually, the transfer policy is going to be discussed at the curriculum meeting.
Okay, that's good. I don't care where it's discussed, but let's.
And then we'll bring it to the board.
Okay, good. I'm with you. Right.
I really thought we would start having rumors about the sky is falling when we had 2 weeks of snow where nobody could get onto the site. I really believe once we start talking about a contingency plan, because we had a trigger in our own mind when we hit a particular date, we're going to build a contingency plan, because you better have it, and it could happen. Listen, none of it, I don't know how to build schools. We are making it up as we go. Nobody's done it in 40 years, and the learning curve is pretty steep. So that's why we're doing contingency plans on absolutely everything, so that we don't get caught short. And if A doesn't work, we're going to B.
Yeah, I've asked this one other time, and it's my own fault for not following through myself individually, but I don't want to be in the way. Would it make sense that if there are board members, so that again, if we're going to bother the folks on the construction site, we're doing it at one time together rather than everyone going at any one time? I wonder if it would be an advantage if you set a date and said if there are any board members that would like to meet on this date, and as far as that goes, the media as well, and go through and see the progress that's taking place. Is that a bad idea? Again, no. We don't seem to get it.
We have hard hats for everyone, and when you have a hard hat, you're welcome on site.
Well, who would be the person that would take charge of making that arrangement?
Mr. Silcott?
So I can't do it for at least a week, but and then
I think you'll be amazed once you get inside the buildings, if you haven't been in, to see the level of finish work that there. I mean, their ceilings are inside the building. There's an awful lot to see inside. I think you'd really enjoy looking at.
I love seeing that building from 229 on Carden Park, and I'm thinking these little ones are going to be looking out over that river, and what a wonderful, wonderful, wonderful opportunity to learn how to read and do math and all the kinds of things that little children need. And I'm excited about going in there, but I'm afraid to go in there for fear of being in the way of the contractors.
No, you won't be. And there are times we've had 22 different trades on site at the same time. It is a beehive of activity to watch these folks moving around and how they do that. So we've got a good template now how to build schools. So get us some more money and we'll build a few more.
Yeah, that's what I want to hear.
Thank you, Rick. Let's see, final item is board committee assignments. I talked to each of you and got some feedback, and Finance Committee Chair is Martin Rucker, Personnel Committee Chair Dennis Sneathen, Curriculum Instruction Assessment Committee Chair is Ms. Danford, and then we will be reestablishing the Policy Committee because we have a lot of work to do there with Ms. Prusman as the Chair. All right. I'll entertain a motion to adjourn.
So moved.
First and a second.
Mr. Sneathen, we're adjourning.
Yeah.